Welcome to this week's edition of Freedom and Prosperity Radio, the weekly radio news magazine that we put together here at the Virginia Institute for Public Policy. My name is Joe Thomas, and you can learn more about everything we do at the Virginia Institute by going to our website, tertiumquids.org. I was asked to spell that by email this week, TertiumQuidsEIEIO. No, we would never redact it. But if you're thinking about giving your mom an unredacted version of the Mueller report, you might want to stop by the florist anyway. While that dominates the news, we're going to lead off here with one of the greats. He is John Malcolm, Vice President for the Institute for Constitutional Government and the Director of the Meese Center of Legal and Judicial Studies at the Heritage Foundation. John, thanks for coming back onto the program. How are you doing this weekend?
I'm doing great. It's a pleasure to be with you.
Well, thank you so much. I want to start off with clarifying for people the difference between a court of law and the court of public opinion, because I have a feeling this Barr and Mueller and Comey all the way down the line has been so much more about the court of public opinion rather than the court of law. I almost wonder, I've only been on two juries, and I remember distinctly at one point somebody said, "Is there a question anywhere in here, counselor?" Let's clarify what is court of law versus court of public opinion as it goes to this.
Yeah, so a court of law is just when charges are brought, or if it's in the civil context, when a civil lawsuit is filed, and then you're dealing with judges and juries and legal instructions, and at the end of the day, a case can settle, or in the case of criminal case, plea bargain. Somebody can be convicted, a judgment can be rendered. That's all the court of law. The court of public opinion is, what do people think about all of this? So there may be an impeachment proceeding coming up in the House, and whether there's public support for that. There will certainly be an election in 2020, and so people will have an opportunity to weigh in on what they think about the president's actions, both positive and negative. And so you're speaking to different audiences. And actually, when Bill Barr was testifying before the Senate Judiciary Committee recently, you had a whole bunch of Democrats who were asking, gee, do you think what the president did was appropriate? Or do you think, did you like what the president did? And Bill Barr said, that's not why I'm here. The department, we're the Department of Justice. We're not the Department of Good Manners. We're here to decide whether a prosecutable case exists, whether a crime was committed. We're not here to decide whether you like the president's tweet or whether it was appropriate what he did or didn't do. I mean, all of that stuff is in the Mueller report, warts and all. Whether it should have been is a different story, but it's all there, and now the public can read it and decide. We've decided that a prosecutable case does not exist, and therefore he's not going to be charged with a crime. Now you decide whether you like what the president did or didn't do.
So talk about that, and that's where I wanted to go with this, John, is, a court of law has certain standards by which you have to reach a certain standard before you can file charges against somebody.
Right.
And, the court of public opinion, we have no such standards, apparently. Though I thought we used to. When I first started in broadcasting, you couldn't just go on the air and say, whatever old harebrained thing you thought without somebody saying, hey, do you have a copy of this program? Or company attorneys want to review it, because you can have defamation suits brought against people still, I believe. But in the case of obstruction of justice, in a sense, that is the center square right now, since no collusion, all of this has been gone by the wayside. Now it's he obstructed justice. What is, generally speaking, the standard by which you have to get to a level before you can actually bring charges of obstruction of justice, John?
Well, at the end of the day, whether it's obstruction of justice or any other crime, a prosecutor has to make a determination. One, given the facts involved and under the applicable law, do I believe that a crime was committed by this individual? And then the second question is, do I think that I could prove that case beyond a reasonable doubt in front of 12 jurors based on competent, admissible evidence. So Bob Mueller wrote this very, very lengthy report, which is now out there in a largely unredacted fashion. There are a few redactions in the report, and it's in 2 volumes. And with respect to the first, he said pretty definitively there was no collusion. Collusion is not actually a crime. So he quickly said, really what we evaluated is whether there was a conspiracy between people in the Trump campaign and the Russians to attempt to interfere with the 2016 election. He said, look, the Russians clearly attempted to interfere with the 2016 election. I've indicted Russian entities. I've indicted Russian individuals. And there's no question that the Russians reached out to lots and lots of people in the Trump campaign and tried to, get inside information and to deal with them, but without success. Nobody in the Trump campaign coordinated with and certainly didn't conspire with the Russians to do anything wrong. With respect to obstruction, as a general matter, there is an investigation. The Department of Justice conducts an investigation to determine whether a crime was committed or not, and somebody can attempt to obstruct that investigation. They can destroy evidence, they can bribe or threaten witnesses, they can do any number of things to try to throw off that investigation. And Bob Mueller, he came to the conclusion that he wasn't going to reach a conclusion. He said, look, there's some evidence out there that suggests that perhaps the president did attempt to obstruct an investigation, and there are other factors indicating that he probably didn't attempt to obstruct an investigation, and I am not going to make a traditional prosecutorial decision. I think that this frustrated Attorney General Barr a little bit, who said, well, look, this is why you were put in this position. It was to investigate this and make a decision. If you weren't going to make a decision, why were you investigating this in the first place? But okay, if you're not going to make that kind of a decision, I will sit down with career attorneys, the Office of Legal Counsel, the Deputy Attorney General, and we will make that decision. And he did. He said that he did not believe that there was a prosecutable case for obstruction of justice against the President of the United States. There was in the background this legal opinion by the Department of Justice that says a sitting president cannot, in fact, be indicted. And Bill Barr said, you know what, we're going to put that aside. We are going to assume for the sake of argument that a sitting president can be indicted, and I'm going to say, based on these facts and the governing law, I don't believe a prosecutable case exists, and therefore we are at an end. Some of the things that he clearly considered to be important to his decision was the fact that the president, in fact, took no action to try to curtail the investigation, that he waived executive privilege. He allowed all of the people on his staff to go in and meet several times with the special counsel's team. He himself, the president, submitted written answers in response to questions from the special counsel. And another thing that weighed heavily on his mind is that not always, but almost always, when someone attempts to obstruct an investigation, they are doing so because they know they're guilty, and that at the end of the day, that investigation is likely to conclude that they are guilty. In this case, President Trump had been saying all along this was a witch hunt, and it turns out that there was no underlying crime. Therefore, if there was no underlying crime, why would an innocent person attempt to obstruct an investigation that was likely to conclude that no crime had been committed? It can happen. Sometimes investigations reveal embarrassing stuff, or it's just an albatross and you want the thing to end. So all of the facts, both in Trump's favor, not in Trump's favor, whether you think they were appropriate actions or inappropriate actions, are all laid out. The Department of Justice has now said there was no prosecutable case there, that the president did not act with a corrupt intent. He was just frustrated, as any president or any person would be under the circumstances, but there's no prosecutable case. And now the people can decide whether they think this was a good judgment or a bad judgment, and also whether they like what the president did here or in any other thing that the president does.
Well, as it should be. We're visiting with John Malcolm on this week's Freedom and Prosperity Radio, and with no less estimable organization than the Edwin Meese Center for Legal and Judicial Studies at the Heritage Foundation. So the Congress for the most part, though, from what I'm understanding, only a couple of members of the House have even bothered to look at the Mueller report, though it's been released. Have had seemingly ample time to come to some sort of determination if they were going to move forward. What would come next? As Robert Mueller said, I'm going to leave this in the hands of Congress if they want to go forward with something in their own purview as a check and balance on the office of the presidency. Is it too soon to say, hey, have you guys decided anything? Is the fact that none of them have actually gone to look at the unredacted version of the report telling, John? What should we be interpreting from this, or are they just trying to get some political mileage out of it?
Yeah, that's hard to say. I mean, so just to clarify, the redacted report is out there. When I say redacted, I mean it's a 448-page report.
Right.
Less than 10% of it was redacted. And what Bill Barr did was he said, you know what, I'm going to put out a second edition that is even less redacted, less than like 2% will be redacted, and I will make that available to members of the Intelligence Committee for both the House and the Senate. And according to reports, no Democrats on those intelligence committees have gone to look at this even less redacted report. So they've now had a hearing before the Senate Judiciary Committee. The House was a little bit frustrated because Bill Barr said, you know what, given the way you all are acting and given the fact that you want to have staff members question me, this is looking more like an inquisition than a hearing, I'm not going to show up. There are going to be more hearings. There's a question about whether Bob Mueller is going to testify. I think at the end of the day he probably will. And so the House is going to continue to beat the drum of the president's inappropriate behavior, suggesting that really it was not only inappropriate but also criminal conduct by conducting hearings there. And the Senate, chairman of the Senate Judiciary Committee, Lindsey Graham, has said, you know what, we're now going to look at how this investigation began, right? So the Bill Barr has said that spying occurred on the Trump campaign. He's made it very clear that, look, he says, I began my legal career at the CIA. To me, spying is a neutral term. You can spy for good reasons or bad reasons. You can spy, with a proper factual predicate to support such an investigation or not. But I believe that spying did occur, and I want to find out whether that factual predicate existed. The Department of Justice's Inspector General is going to be issuing a report very soon about whether or not there was abuse of the FISA process. That's the Foreign Intelligence Surveillance Act that uncovered a lot of these conversations that took place between Russians and people in the Trump campaign, including conversations between Michael Flynn and Ambassador Sergei Kislyak about sanctions. And that report, I expect, is going to be very, very significant. Michael Horowitz is a very thorough lawyer. His report on the FBI's conduct in the Clinton email server investigation was very thorough and scathing. He's going to come out with another report about Jim Comey and whether he divulged classified information. So there's going to be plenty of fodder on both sides of the political aisle for people to hold hearings and pick apart. And all of them are kind of playing in part to their base to gear up for 2020, and we'll have to see whether the House and the Democratic base is sufficiently incensed that they decide to begin impeachment proceedings.
Do you feel like, because I do from where I sit behind this microphone, John, that this is part and parcel of why they need to go out with the campaign of Bill Barr is a liar, Bill Barr lied to Congress, Bill Barr should be fired because he lied to Congress? First and foremost, their premise that he lied to Congress all revolves around the letter from Robert Mueller regarding his press conference, correct? What exactly are they accusing of Bill Barr of lying to Congress about? Because they don't really clarify that when they go on TV and say it.
Yeah, it strikes me as being pretty flimsy. So just what happened is that Bill Barr put out a letter on March the 24th, in which it was a 4-page letter. He sent it to the ranking member and the majority members in the Senate and House and said, look, I'm going to be working on getting you something more fulsome and trying to get this report out as quickly as I can, but I want to let you know here are the bottom line conclusions of what Mueller has said in his report, because I don't want you waiting around for another month or two before I can go through this report and get it to you. You need to know what the results are. 3 days after that, Bob Mueller writes a letter to Bill Barr, which Bill Barr characterized as being a little bit snitty, that says, you didn't put out enough about the context of our conclusions and the press is saying some bad stuff about this, I really think you should put out the executive summaries that we also prepared as part of our report. Bill Barr picks up the phone on the next day on March 28th, calls Bob Mueller and says, Bob, why didn't you pick up the phone? But putting that aside, did you think there was anything in my 4-page letter that was inaccurate or misleading? And Bob Mueller says, no. I don't think there was anything inaccurate or misleading. I just wish you would put out more. And Bill Barr said, I have no interest in putting out anything piecemeal. I'm going to spend my time trying to work on this report, and we'll get it out as soon as possible. A few days later, he goes and testifies before the House Appropriations Committee, and he is asked a question by Congressman Charlie Crist of Florida that says, look, we're hearing stories. There are reports out there that members of the Mueller team somehow think that something was inaccurate or, inappropriate. Do you know anything about that? And he said, no, I don't. Now, this is the question that Nancy Pelosi says he lied. Bill Barr was asked about this the other day. He said, no, guys, I'm talking to Bob Mueller, and I just asked him whether there was anything misleading or inaccurate that he knew about. He said no, because the reference to there was unclear whether it was talking about members of the Mueller team or reporters who were issuing these stories. I don't know who the members of the Mueller team are referencing. I don't know what they're talking about when they say that something is inaccurate or inappropriate. I have no idea what that is all about. But that is what Nancy Pelosi is latching onto. The whole conversation actually struck me during the hearing as being very bizarre. I mean, here they were talking about Bill Barr's summary letter and Bob Mueller's reaction to it, saying, please put out more information. The whole report is out now. I mean, the whole idea was to discuss what was in this report and whether it was, Barr's conclusions were supportable or not. And they're talking about this exchange of letters before the report came out, talking about whether he had disclosed enough in his summary. I likened this to commenting about whether or not a movie trailer is somehow accurate once the movie's out and in the theater. I mean, once the movie's out and in the theater, who cares about what the movie trailer says or doesn't say? But that was how that's how the hearing went.
And technically, the letters were to the ranking and majority members of the committees, not to the press. It's not like he issued it to the Washington Post. Whether those members of the House and Senate released it themselves, that was another matter. But I also, this goes back to court of law versus court of public opinion, John, because in the court of public opinion, it seems like they're trying to pre-disparage the attorney general so that if anything comes out regarding the Clinton email server or abuses in the FISA process or playing fast and loose with the FISA process or how the dossier was used to concoct this whole scenario, is going to be tainted because, that's AG Barr who's just acting as the president's lawyer, so of course he's out there doing it. You might as well have just hired Rudy Giuliani to do it for you, or Michael Cohen, for that matter, if he wasn't in jail. So that's what I feel like, is they're trying to pre-taint the water on anything that the attorney general does. Can he still do it, or do you think he's compuncted to even care?
Well, trying to impugn people's integrity and reputations is just a blood sport here in Washington. Bill Barr has an outstanding reputation for good and sufficient reasons. He's been a dedicated public servant. This isn't even his first time serving as Attorney General, and so I don't think it's going to bother him personally, but you are right, as the Democrats, or many of them, not all, are trying to portray him as the president's toady. That way they can dismiss his conclusions that the president did not, in fact, commit obstruction of justice. And you're also right. He has now said we're going to look at how this investigation began, whether there was a proper factual predicate, and they will be able to say, if the department does conclude, and I don't know whether they will or not, that this wasn't a proper investigation, there was no proper factual predicate, that this was being done for political reasons only, that they'll be able to say, see, well, what did you expect from somebody who's the president's toady?
Yeah, exactly. John Malcolm, the Meese Center at Heritage Foundation, this is the easy part of this. Once we're done, and there'll be a day when Nancy Pelosi isn't in the House and Donald Trump isn't president and Chuck Schumer isn't in the Senate. And the Department of Homeland Security is still going to exist. FISA courts are still going to be there. I interviewed Governor Tom Ridge when he was leaving Pennsylvania to take over this department, and I said to him in Pennsylvania, we were on a station there, I said, Tom, why do I get a bad feeling about the Fourth Amendment and our protections? What can you tell me that would assure me? And he said, well, these FISA courts are going to be so strict. He said, like, if you've ever tried to get a warrant for, to a wiretap at your local police department, this is going to be 100 times harder. And now the real crime in this seems to be how easy it was for these FBI agents to leak a story, use the story that they leaked to the Washington Post as a premise to get a FISA warrant to surveil an American citizen. It seems like it's ridiculous almost how easy our Fourth Amendment protections are being danced around. How do we fix that part?
Well, I'll push back a little bit. I mean, okay. I think the FISA process, I know some people who have been FISA court judges. I know people who presented FISA warrants, is actually, under normal circumstances, a fairly rigorous process designed to protect the Fourth Amendment. It's important work to try to find out what spying operations are being done by our enemies, whether they're terrorists or nation states, against us. It's a very powerful tool, and it shouldn't be abused or misused. And certainly there is the suggestion, we'll find out soon enough when Michael Horowitz's report comes out, that process was abused by agents who presented FISA warrant applications that sort of hid the ball. And that is a serious problem that should never happen. And I think that FISA courts were probably pretty careful to begin with. They're going to be even stricter. Mm-hmm. Perhaps you think that is a good thing because it prevents political abuse, which it does, and it helps strengthen the Fourth Amendment, which it certainly does. But anything that makes it that much more difficult to try to find out what our enemies are up to has a potential downside too. I think there is no question that this is a very powerful tool and never should be or should have been abused for political purposes. It will be important to uncover that and important to make sure that it never happens again.
It seems like in what we've learned about, what the FBI agents were doing, they had a familiarity with this particular judge. Is that something that needs to or could be even tweaked where, recusals of certain FISA judges to, make sure that there's no, we're in the same golf club or anything else that would happen in a regular court of law if the judge was a partner of the defense attorney. They'll often recuse themselves, saying, "I know this guy. I don't want to rule over his case." Those kind of things need to be there as well, because that seemed to be a little bit of what these FBI agents played on, was a familiarity with the FISA judge.
Yeah, I don't know whether that occurred or not.
Sure, I mean, it's something we'll find out.
There are judges. Well, look, I mean, FISA court judges are appointed for a long time, and they sit periodically, and the people who present affidavits and applications to them tend to be repeat players. So the fact that a judge gets to know somebody who appears before them, I don't think is necessarily nefarious at all. I don't know the ability of applicants to cherry pick the judges they're going to present affidavits to. I mean, some judges, even in just regular Article III courts, are known as being easy judges to get warrants from, and others who are probably scrutinize things more. I think there's no question that if you have any kind of a relationship, financial, social, otherwise, in which it can be reasonably questioned, your independence can be reasonably questioned, it's appropriate for a judge under those circumstances to recuse him or herself. Whether those circumstances existed here or not, I just don't know.
Well, but I think that's where if we get past all the name calling and the politics of it, that's the part that has bothered me the most about this. Is always been very nervous about abuses against the Fourth Amendment. We see them here with our asset forfeiture, Fifth Amendment, Fourth Amendment, the police, taking people's property before people are even convicted. So there are so many places where I feel like our Bill of Rights has been danced around. I just want to make sure the people who are supposed to be on the wall, as it were, protecting the Bill of Rights are doing that. Right. And I so deeply appreciate your visit with us this week on this Mother's Day weekend special. I appreciate it, sir, and everything you do at heritage.org. And, of course, the Daily Signal is the daily newspaper from the Heritage Foundation. Keep doing what you keep doing, and it never seems like we're ever at a place where the folks like you guys can stand down, but we deeply appreciate anything that was started by Russell Kirk has got to be a good thing, and thank you so much, sir.
It's been kind of you to say, and it's been a pleasure being with you.
When we come back on this week's edition of Freedom and Prosperity Radio, Burdens of Freedom with Lawrence Meade, professor of politics and public policy at New York University. We'll be right back with that next on Freedom and Prosperity Radio.